Guys. So today we will be doing what's this? We will be doing criminal court procedure, chapter 21. This is the trial before a superior court. We'll be discussing the procedures that occur during a criminal trial in a superior court to ensure that the trial is fair and all parties are involved. We'll focus on how the charges are brought and who is involved, as well as how decisions are made. So Section 114 deals with understanding and indictment. So from this section, your takeaway is basically to explain what is an indictment, why it is used, and what information must contain it. So let's say when an accused is brought to a superior court for trial, the charges against them must be formally laid in a document which we call an indictment. So an indictment basically serves as the official charge sheet and is framed by the DPP. It must include, just as your normal charge sheet, the accused name, the address, nationality, gender, and age. So let's say Sheila is accused of robbery. The indictment would then state that Sheila, a 27-year-old female, or South African citizen, charged with robbery on date and such a location. It just has to state the details surrounding that. So that is it for your charge in superior court. We bring it out by in a way of an indictment, not a charge sheet. So we're supposed to give you a question and they'll ask you what is it explain what is it the difference between an indictment and a charge sheet. Then you know that the charge sheet applies in your lower courts and indictment applies in your superior courts. And it is framed by the Attorney General, also known as I think the BPP, and must include basically the details of the accused as well as the crime that is being brought against them. And then trial in superior court by judge with or without assessors. So here you are taking basically what is the role of an assessor in a trial and how they assist the judge. So in a criminal trial, a judge may sit with assessors. These are now your individuals who have experience in law specific subject matter of the trial. Their role is basically to assist the judge in making a determination on the facts. They are sworn to give a true verdict on based on the evidence that is before the court. So, for example, in a trial involving a complex financial crime, an assessor with a background in finance might be called to help the judge understand part of the intricate issues and financial transactions. So that would be the role of an assessor. They are also there to assist the court. And then going to the next one at section 146, reason for decisions by superior court in criminal trial. So we basically explain how the trials are conducted, the judge's role in making a decision. So during a trial, the judge is responsible for legal aspects of the case. We know that at this stage. This includes making decisions on question of law, whether certain evidence can be admitted. When it comes to factual matters, the judge obviously has to work with the assessors to determine the verdict. But in some situations, the judge may elect to make the decisions alone because maybe he's worked in that industry for quite some time now. He is well versed in that area of law. He can make a determination. So then the assessor would be there to assist or not. It's purely up to the what's this? The judge if you would like to call him. So that is the role of a judge, and that is the instance, the reasons for his decision, and the liberty that he can sit with or without an assessor. And then also having to give reasons why judges provide reasons for their decision. So in criminal trials, it is very crucial for the judge to provide reasons for their decision. Because now the transparency basically helps that justice is seen to be done. The judge must always explain the rationale behind their decision, especially when deciding on matters of law or the outcome of trial. We always want to make sure that, okay, fine, he reached his decision impartially and guided by legal prescripts. So that would be the reason for that would be the reason we need reasons of the judge's outcome, basically decisions, yeah. The reasons for decision. That's basically about it. And then now we are going to the discharge. It's section 174 of the Criminal Procedure Act. Okay, there it is. I got it. So always keep your mind open when studying criminal court practice. They're not going to ask you everything, but you have to always ask yourself, okay, I've got section 146. What can they ask me? Maybe they can ask me, give reasons why it's important for a judge to provide reasons for the decisions. So you always have to look at that. Like in my previous criminal court practice video, you always keep your mind open to a question and be able to answer it there and then as you go through that specific section. Then we've got section 174 of the Criminal Procedure Act. Now this deals with the discharge of an accused at the close of the prosecution's case. So section 1 allows an accused person basically to be discharged at the close of prosecution if it's in the court's opinion that there is no evidence that the accused committed the offense charged or any other offense which he may be convicted. So what the court will then do is they will return a verdict of not guilty because the prosecution has failed to provide sufficient evidence to support the charge against the accused. This is basically to safeguard and prevent the accused from being convicted. I mean, we don't have enough evidence. It's sufficient. So how are we reaching a verdict of guilty? Just basically on speculative evidence. So the principle behind section 174 basically is that no one should be convicted without enough evidence. If you don't have enough evidence to establish a prima facie case, let us discharge the accused. So when does this happen? So the the prosecution would have presented their case and the defense had the opportunity to challenge the evidence. So then the court must determine if there is enough evidence that would support the conviction. So let's say we've got a case against the accused person and saying he was at the crime scene, but there's no evidence linking them directly to the crime. For instance, your fingerprints, your DNA, eyewitnesses. I mean, at this stage, then the accused may then be entitled to request a court for a section 174 discharge because you can't even place me at the scene. Like, how is it that I did this? So how does section 174 works in practice? The prosecution obviously be in chief, which includes calling witnesses and submitting evidence to establish basically that the accused committed the alleged crime. As soon as the prosecution has concluded its case, then the defense will have the opportunity to argue that the defense will have the opportunity to argue that the evidence is insufficient to prove the charge beyond a reasonable doubt. And then the defense request a section 174 discharge and basically place it to the court that the prosecution has failed to make a case against the accused. After hearing this, the judge will then evaluate the evidence presented. If the judge really believes that no reasonable court could convict the accused based on such evidence, then the judge may also then discharge the accused by entering a verdict of not guilty. So So for instance, let me make an example like Sheila is charged with robbery. The prosecution's case is based on testimony of Christy, who claims to have seen Sheila near the scene of the crime. And then Christy testifies that no, Sheila was seen standing near the store during the time of the robbery. However, Christy does not state how Sheila was actually involved in the robbery or had any weapons and no forensic evidence, fingerprints, your CCTV footages links Sheila to the crime. So then obviously Sheila's attorney will come and argue that the prosecution's case relies entirely on testimony of Christie, who only placed Sheila near the scene but did not witness any criminal activity. Like you literally show Sheila standing there, but is there anything else to that? No, there isn't. Um, then Sheila's attorney may also point out that there is no forensic evidence. I mean, there's no other witness connecting Sheila to the robbery. Then, obviously, then the judge is at liberty to decide that the prosecution has failed to establish a prima facie case and there is no concrete evidence linking Sheila to the robbery. And then the judge may then grant the Section 174 discharge and deliver a verdict of not guilty because really there's no reason that we would be um, prosecuting Sheila based on speculative evidence of just Christie, that is. Does not even say I saw her carrying something, it's basically just saying, uh, I saw her there. So, as a wrap, Section 174 is basically a vital tool that the accused can use in a criminal trial to ensure that they're not convicted um, without sufficient evidence. And it also gives the court to step in and prevent a trial from continuing if the prosecution has failed to present a case that could lead to a successful conviction. So here they can ask you something like, um, when can a accused apply for a discharge? At close of proceedings, then the reason would be there isn't insufficient evidence. What verdict can the court come to? A verdict of not guilty. So also keep your mind open. You're advising a client, just like the Christian Sheila scenario. There's no sufficient evidence. Basically, this person literally saw Sheila standing there and claims that she was part of the robbery other than having concrete evidence that links Sheila directly to the crime. Unfortunately, we cannot convict her. And yeah, that's it, guys. So I will post another video of two more bullets from the criminal court practice. So I will be doing two just to avoid the videos being lengthy. I would rather have you invest a good 15 minutes where you can take away something than a good 4 hours where you can barely remember anything. Otherwise, that's it from me, guys. Hope you have a great day.